بسم الله الرحمن الرحيم والصلاة والسلام على أشرف المرسلين. We are going in this lecture to resume in the commercial law for business students for Al Isra University students, and we are going to continue and start on page 115 for selling and serving food or drink for consumption on all of the premises is a sale subject to the implied warranty of merchantability. The food must be fit for the ordinary purposes to which it is put, for human consumption, of course. The problem is common. You may bite into a cherry bit in the cherry vanilla ice cream, or you choke on the clam shells in the chowder. Is such food fit for the ordinary purposes to which it is put? There are two schools of thought. One asks whether them food was natural or prepared. This view adapts the seller's perspective. The other school of thought seeks what the consumer's reasonable expectation was. The first test is sometimes said to be the natural foreign test. If the substance in the soap is natural to the substance as bones are to fish, then the food is fit for consumption, for human consumption, of course. The second test, relying on reasonable expectations, tends to be the more commonly used test. This is the selling and serving food or drink. Right now we are moving to section number 2 on page 117. We are going to talk about negligence. Negligence is the second theory raised in the typical products liability case. It is a tort theory as compared to breach of warranty, which is the cause of a contract theory, and it does have this advantage over warranty theory. Privity is never relevant. A pedestrian is struck in an intersection by a car whose brakes actually were defectively manufactured. Under no circumstances would breach of warranty be a useful cause of action for the pedestrian. There is no privity at all in this case. Typical negligence claims. Design defects and inadequate warnings. Negligence theory in products liability is most useful in two types of cases: defective design and defective warnings. Defective design from the manufacturer or from the factory actually, and defective warnings. Design defects, manufacturers can be and often are held liable for injuries caused by products that were defectively designed, because they are the reason for that. So they are liable actually, the factory or the manufacturer. The question is whether the designer used reasonable care in designing a product reasonably safe for its foreseeable use. The concern over reasonableness reasonableness, and standards of care are elements of negligence theory. Defective design cases can serve problems for manufacturing and safe engineers. More safety means more cost. Safety means more cost to the buyer, of course. Designs altered to improve safety may impair functionality and make the product less desirable to consumers or customers, of course. At what points safety comes into reasonable balance with performance? Cost and desirability is impossible to forecast accurately, though some factors can be taken into account. For example, if other manufacturers are marketing comparable products whose design are intrinsically safer, the less safe products are likely to lose a test of reasonableness in court, because the court has the final word about that or these kind of cases. Warning defects. We noted that a product may be defective if the manufacturer failed to warn the user of potential dangers. Whether a warning should have been affixed is often a question of what is reasonably foreseeable, and the failure to affix a warning will be treated as negligence. The manufacture of a harmful grass killer with poisonous ingredients is certainly acting negligently when it fails to warn the consumer that the contents are potentially lethal because of the poison in the product. The law governing the necessity to warn and the adequacy of warnings is complex. What is reasonable turns on the degree to which a product is likely to be missed and whether the hazard is obvious. We finished section number 2. We are going to proceed in section number 3 on page 119. Section 3, strict liability and tort. Strict liability and tort. The warranties, grounded in the commercial law, are often effective in assuring recovery of a plaintiff's injury. The notice requirements and the liability of a seller to disclaim the warranties remain bothersome problems, as does the privacy requirements in those states that continue to adhere to it. Negligence as a product's liability theory obviates any privacy problems, but negligence comes with a number of failure defenses. To overcome the obstacles, judges have gone beyond the commercial statutes and the ancient concept of negligence. They have fashioned a tort theory of products liability based on the principle of strict products liability. One court expressed the rationale for the development of the concept as follows: the rule of strict liability for defective product is an example of necessary paternalism, judicially shifting risk of those by application of tort doctrine, because a commercial law scheme fails to adequately cover the situation in that sense.